Hey, so you have an active warrant and you're wondering how you fix it. It's very simple. It's called a motion to recant or motion to recall. You don't do a motion to quash because a motion to quash can be used against you. A motion to quash is more appropriate when you want to avoid a judgment or you want to avoid a part of a judgment or some type of finding of fact and conclusion of law. So a motion to recant is the best solution. We've heard in the past that a warrant is a negotiable instrument. And when it comes to negotiable instruments, they just stop there. Whoever told us warrants are negotiable instruments, they stop there. But the continuation of that and the enforcement of that knowledge that a warrant is a negotiable instrument is that you have to recall it. You have to recant it. Since a warrant is a negotiable instrument that's enforceable by the bearer, it has to be withdrawn. Like you withdraw a check, like you reverse an electronic payment. Yeah, you have to recall that warrant because that warrant is a mandate for an action to occur. And believe it or not, warrants, no matter how bad it appears, no matter how much it's been instilled upon us to think warrants are bad and these guys are some evil people, it's actually a form of due process. And let me explain why and how. A warrant is a show cause, meaning there is a levy against a name whereby there's a supposition that you're sharecropping it. And before a final determination and award in a commercial venue, which is the court, the bank, is determined, an award, the deed, they issue a warrant as a form of due process to say, okay, before we rule against this thing that you might have an interest in, show us why you shouldn't be guilty. Because a warrant is just saying, hey, there's a claim and a dispute going on here, but you're not showing up. The reason why they're issuing it in the first instance is because you never showed up one way or another. I've seen situations where people did a notice of special appearance and then they physically appeared, but they did a whole bunch of other stuff that they weren't supposed to do. All that, giving them definition of what something mean, all that, accepted for value, whatever it is. They did all that. Then they showed up physically, but yet they issued a warrant. So you have to know what you're doing. Just don't go out there gung-ho. But your solution to an active warrant is a motion to recant, not a motion to quash, because a motion to quash can be used partially against you to appear as though they fully afforded you due process. A motion to quash is best when you want to remove or suppress certain partial information, because warrants can be quashed partially. But when you recall it, you withdraw it and you reverse it completely, since we know it's a negotiable instrument and you can reverse that payment. When you quash it, on the other hand, you're merely suppressing part of the evidence. So for instance, if the warrant is enforceable throughout the state, or if it's a fugitive warrant throughout the North Americas, then they can basically quash the stipulation whereby it's only going to be enforceable in certain states or certain counties, but the warrant is still active nonetheless. You want it to not be active. That's just the way out if you give them a motion to quash, and they will use that way out, and that warrant is still going to be active. Some warrants expire. Some warrants are only enforceable for a certain period of time. Some warrants, if they don't stipulate the enforceable period, it's presumed to be perpetual. So now if you do a motion to quash, they will use that and say, yeah, we're forging a due process. We accept your motion to quash. We're going to quash the perpetuity and we're going to keep it active for 30, 40 years. What's the difference? If you're in your 40s or your 30s and the warrant is active for 30 or 40, what's the difference? It might as well follow you to the grave. So do not do a motion to quash a warrant. Do a motion to recant it, withdraw it, recall it, because it's a mandate that's based on due process. But there are two main conditions for a motion to recant to actually work. The first condition is good faith. The second condition is an emergency circumstance. Good faith in the sense that you're going to show up for the sole purpose of challenging the constitutionality of the case. Because if you don't bring that up and you're merely showing up, yeah, they will recall it, but it's also deemed and presumed that you've accepted the liabilities by showing up. called subject matter jurisdiction. The error in the name is cured when the body shows up. It's a maxim of law. The second condition, which is the emergency circumstance or the undue burden, is that you didn't show up in the first place, which caused the warrant to be issued because of some emergency circumstance. That way you demonstrate that you're actually still in honor within that commercial venue. So what is recant? To withdraw, to repudiate formally and publicly. What you want is a motion to recant. What is the definition of a warrant? Everybody has beaten this to death, given that it's a commercial term, but they just stop at the fact that it's a negotiable instrument. They don't tell you how to fix it. The solution is a motion to recant. If used as a verb, which usually that's how it is because it's an action commanding one or a lot of parties to engage in something. So usually the warrant for someone's arrest, bench warrant, whatever it is usually in the form of verb. Then contract, meaning the performance. The performance is that you were supposed to show up to determine whether the levy that somebody has against you as a debtor, aka defendant, is valid or not. If you didn't show up, that means you haven't performed because you're on contract, whether you realize it or not. To engage or promise that a certain fact or state of fact, meaning whatever they brought against you, in relation to the subject matter, whatever they brought against you, is or shall be as it is represented to. Is it true or not? Are you guilty or not? How do you choose to deal with this? Do you want to challenge the constitutionality? Do you want to deal with estoppel? Do you want to counterclaim? What do you want to do? We don't know. So we have to afford you due process by issuing a warrant. So warrants are not as bad as you think it is. They're bad if you don't know how to deal with it. If you really see it for what exactly it is, then you know how to approach it. It's called a motion to recant under those two conditions of good faith and extraordinary circumstance or emergency circumstance. In conveyance, meaning transference of title, which is what they do whenever they give orders and whatnot. They grant somebody an award of, okay, now this person pays you this fine, or they're sentenced. And whoever the creditor is, which is a plaintiff, wins. And whoever the defender is, which is a debtor, which is you, who they're issued a warrant against, loses. So that is the conveyance of language. That is the conveyance of title. The title of who has the right of action, right of claim. Get it? To the contract, to the premise, to the facts, to the subject matter, to the claim being brought against you. In conveyance, to assure the title to property sold by an express covenant to that effect in the deed of conveyance. The deed of conveyance is the final court order saying you're guilty. But before they do that, they have to afford you due process by figuring out performance to see what do you want to do and how do you want to do it. To stipulate an express covenant that the title of a grantee shall be good and its possession undisturbed. Then once we issue this title, the order, we want to make sure that before we do it, there's no dispute, because if there's a dispute, then the levy cannot become a lien. A levy is a temporary taking of a property, which is what they do every time they sue you. They're sharecropping that name and that right to it because they're tapping into it through the Kafirs. And the lien is once that final order is done that says you're guilty or not guilty. If you're guilty, then they've effectively put a lien on that name. But they afford you due process. So warrants aren't necessarily bad because it's actually assisting you. So if you know how to deal with it, you deal with it through a motion to recant. Now, someone that I know that does an excellent job when it comes to the preventative aspect of the headache of being arrested or being just snatched up through injunctive relief is Jonah Bay. So full 100% credit goes to him for that. But that is preventative. Let's be realistic here. Without taking anything away from him, Jonah is an excellent masterful teacher, and I really think you should go to him to learn more about that. There's no need for me to talk about that here. The credit is to him, so go to him for the injunction. But if you have an active warrant, you need to deal with it. Don't run. Don't try to look for an easy way out. Do an injunction for the future, but deal with it, or else that thing will follow you forever, and it's going to hurt you during the time you don't expect. So do a motion to recant, motion to recall, because this is a negotiable instrument that is withdrawn or reversed. That's the solution to warrants. We've been told that it's a negotiable instrument all these years. Well, there's a solution. Withdraw or reverse that negotiable instrument, because the holder of it enforces it. The holder of it is whoever it's issued to, which is the sheriff, the police department, the state police, whatever, whoever, marshal, Those are the holder, so they can enforce that negotiable instrument. Get it? So withdraw it, recant it, motion to recant. That is your solution to an active warrant. And if you want further details, deeper details, and maybe some other things of this nature, go to my Patreon at Subtle Substance, and a lot more details and subtleties about things like this and more are went over. Best of luck.